Okay, so the time now it is 2:40. So my name is Tiffany Dubon Yard. For those of you who don't know me, I work in the Office of Student Life, specializing in civic engagement. And today, in collaboration with Justice at BCC, we have the New York City Commission on Human Rights. I'd like to introduce Ayad. I don't want to mess up your last name.
Al
Aga.
Gabiali.
Oh, right. I was going there. Ayad Agabiali and co-presenter Abraham Tejada.
Yeah. So hi everyone. Thank you so much, Tiffany, and thank you to the Bronx Community College. A shout out to CUNY. As you know, Tiffany, maybe we have done events together previously, and I have always mentioned with pride, as a graduate from the CUNY system, we got to give, much love and appreciation and, lift our community with these resources and these presentations that we try to amplify as well as empower one another. And here at the Commission on the City Commission on Human Rights, we try to do that and empower New Yorkers on their rights. I'm here today with my colleague Abraham. He works out of the Brooklyn office. I work in the Bronx. We have offices in all over, but today is a very great and important topic, which we hope that you please share with your friends and family members as well as neighbors. um, the, the city human rights law and the criminal history and discrimination in employment, and we'll talk more about the Fair Chance Act, which is one of the laws that the commission enforces in New York City. But just a quick disclosure, this presentation is designed to give you an overview, an outline of the commission and the human rights law, and and in no way should be constructed as an executive outline of the commission's duties or the human rights law itself, because it goes into complex on the different divisions and different protected statuses and within the law. So please, for any complaints or questions, you could always reach out to us, and we'll definitely direct you to the right folks or to the right um, you know um, bureaus. Abraham and I, we work out of the Community Relations Bureau, but we also have the Law Enforcement Bureau. We have other bureaus as well. Before I move on, I want to give, the opportunity for my colleague to introduce himself and give you a background and what he does. Abraham.
Thanks, Ayad. Like was said, I'm Abraham. You call me Abe, much easier. I'm lead advisor for reentry services at the commission. So my job is sort of to focus on those justice involved people and communities, formerly incarcerated people, people with any histories of arrest, to educate them about the Fair Chance Act and about other types of discrimination that may intersect with their experience. So I've been doing this for a long time. Been visiting facilities like Rikers Island and Queensboro for over 10 years. So I'm excited to do this work and excited to be here with you today and talk more about this, and hoping I can shed some light on the Fair Chance Act and how this law really does serve and help so many people in New York City. Thank you,
Right.
Aya.
No, thank you, Abraham, or Abe. As my colleague mentioned, really, uh, we try to empower New Yorkers, because the most important thing here at the commission is for New Yorkers to know their rights, right? And if we have laws on the books like the, Fair Chance Act, and this is what I always tell New Yorkers or people that I meet, and when I came at the Bronx Community College last month, I, met so many students, and I always said, if you don't know, or if you don't, come forward with your complaints, these laws on the book could be useless, right? We could have them on the books for decades. But if we don't enforce them, they mean nothing, right? And that's why we want New Yorkers to be empowered and know their rights, and know the law, right? And make sure that they practice their rights. So just a quick overview, of the New York City Commission on Human Rights, as well as we're going to cover the employment discrimination and protected classes, and then we'll go into depth on the arrest or conviction records and the Fair Chance Act, and how that, that plays a big role in employment. Exceptions under the law, scenarios. We're going to give you some examples today and how to contact the commission and the process. So this is our team, our wonderful team, with our commissioner, Annabelle, and these are our colleagues in the commission. So the New York City Commission on Human Rights and the City Human Rights Law. So the City Commission on Human Rights enforces the city's human rights law and educates the public on their rights and responsibilities under the law. The law also is the most anti-discrimination law, of New York City, but it's also one of the most progressive and expansive civil rights laws, in the nation. So what is the commission? Who we are, right? So we have the Community Relations Bureau, as I mentioned previously. That's us, me, and Ape, which promotes equality, understanding, mutual respect. We work with schools, community groups, faith-based organizations, and colleges like the Bronx Community College, educates the public, leads programs and campaigns, hosts trainings and presentations. This is considered training for you guys to be trained on the Fair Chance Act law. So we also have our colleagues in Law Enforcement Bureau, which is accept complaints. So initiate investigations, files with the commission, initiate cases, brings cases before the city's Office of Administrative Trials and Hearings, which is oath. And they come to settlements as well, with the complainant and the business, let's say. So that's just a quick example. But we also have the Office of Mediation and Conflict of Resolution, which provides mediation services to facilitate resolution of cases filed with LEB, cases that are also referred by LEB, which is the Law Enforcement Bureau, and all parties must agree to mediate, independent from any other commission office, so we ensure neutrality. And there's the Office of the Chair, which is, it issues the final decision, orders, and legal enforcement, guidance, rules, and regulations, which they also draft policy and legislation, engages in policy discussions with the commission stakeholders. So what is the city human rights law? Simply known as to prohibit discrimination in several areas, which is employment is number one. Public accommodation, that's like libraries, parks, supermarkets, anything that you could have access to or the public has access to. Housing, and then discriminatory harassment and bias-based profiling by law enforcement. And that includes law enforcement, obviously, but and also in most cases the last incident of discrimination must have occurred within the last year to file a complaint with the commission. So for gender-based harassment, the time period to file has been extended to 3 years, and it only covers incidents within the 5 boroughs, New York City. Individuals may also file a claim in court up to 3 years after the last Discrimination Act instead of going to the Law Enforcement Bureau. So they could do their own thing. Employment discrimination and protected classes. So we just want to remind New Yorkers, every New Yorker deserves a work environment free from harassment and discrimination. I know you guys are maybe, many of you are still in college and, going through the process, getting your associates and your bachelor's and then heading work for a firm or in the public service or wherever. Just know that with these laws in place, they are definitely there to protect you and make sure that you have a work environment that's free from harassment and discrimination. So it is illegal to discriminate against employees, interns, job seekers, on the basis of like age, arrest, or conviction. And these are the different protected classes that the commission protects under the law. And that includes caregivers, color, credit history, creed, disability, gender, and much more, right? And these laws apply for everyone, regardless of immigration status in New York City. So you're protected under the law. So who is protected? Individuals may file with the New York City Commission on Human Rights if they work in New York City, or the employer has four or more employees for most areas of the protection, right? The last incident of discrimination occurred within the last year and occurred in New York City. And as mentioned, previously, for gender-based harassment, the time period has been extended to 3 years. So that's different from the regular incident of discrimination, you know. So determining if an employer has four or more employees. So the head count includes employers themselves, independent contractors, and freelancers, employers' parents, spouse, domestic partner, or child if they are working there. That's like a family business, right? Employees do not need to all work in the same location. So it could be like let's say an LLC or a corporation that has multiple spots in New York City, and that considered to be a business with more employees because it's still under the same LLC or same corporation. So we'll make the calculation, but we'll also do our own investigation. But we can't do that without your complaint. That's why we need you to complain about any anti-discrimination incidents that you may have faced. So protections in employment, right? Many kinds of employees have rights under the human rights law. That includes interns, paid or unpaid. Everyone is really treated the same, right? Undocumented workers, like I mentioned, the law protects all New Yorkers regardless of immigration status. Part-time or probationary workers, domestic workers, independent contractors, freelancers. So, the law protects a whole set of employee range. So credit and criminal history, and this is where my colleague will take it from here. Abe, so if you want to take it from here.
Shit, thanks, Ayad. So, credit and criminal history protections. So, there are protections against discrimination based on credit history under our law, as well as arrest on conviction record. Normally, these two are talked about together because they both went into effect around the same time. The Fair Chance Act, which we are going to talk about a little bit, which the second bullet point alludes to, in which it says if an employer wishes to rescind a job offer, terminate or fire an employee, or take other adverse action because of a person's criminal history, they must first follow the Fair Chance process. The Fair Chance Act and the Fair Chance process went into effect in 2014. And so we're coming up on the 8-year anniversary. The credit history portion of our law went into effect in 2016. For the purposes of today's workshop, we're not going to be talking that much about credit history, but it's just something good for everyone to know. And there are exemptions that apply to both protections, of which we'll talk about when it comes to the Fair Chance Act. Next slide, please. All right, so employment protections, right? Um, you can go next slide. Yeah.
Yeah. Do you want to
Um,
play this video, Abe?
we can try. It's a minute long. If the sound doesn't work, the subtitles
Uh,
do work.
does the sound work?
When
I
you
think you have to change
shared,
the settings. Yeah.
I was gonna say, when you shared your screen, did you click on the two options that said optimize sound and video? Because you need to click on that. So open up your, oh, okay. I was gonna say, open up your share.
We don't have to watch the videos either. If it doesn't work, it's
And we
completely
could
fine.
send the link.
Yeah.
That's
All
not an
these are
issue.
on YouTube as well, so you can find all of them.
So let me.
Yes. So, yeah, right. So if we talk about the first area of the law, when we think about this employment discrimination or of any kind, right? But especially with fair chance and arrest or conviction record discrimination, the first dimension or the first area where the law applies is in job postings and applications. So one important thing to recognize is that employers are not allowed to mention anything about criminal history when they advertise a job. So in the past, not as frequently these days, but in the past, like when I started doing this work, when the Fair Chance Act first went into effect, we would see job postings that would say no felons, clean backgrounds only, must be able to pass a background check, right? If you have a record, do not apply. If the advertisement has any of those types of statements, it could be considered a violation of our law. So these are exactly the types of things that are prohibited when it comes to job postings under the Fair Chance Act. And similar to that vein, right? Not only can the poster not have language that discourages someone with the background from applying for that job, but most applications should not ask a person about their background or ask them to authorize a criminal background check. So if there's a question on the application that asks, do you have an arrest? Do you have a conviction? Or can do you authorize us to do a background check on you? If that's part of the application, that in itself could also be a violation. Now, this is something that is still very prevalent. I hear a lot that this is something that's still happening. And it doesn't matter sort of the size of the employer. It doesn't matter if the employer is a mega company that operates around the country. If they're operating in New York City, that application should not have questions about arrest or conviction record on it. And then there are some exemptions, which we will get into later. But for the vast majority of jobs, 95% of jobs in New York City, retail jobs, construction jobs, maintenance jobs, office jobs, that should not be on the application. No questions about arrests or convictions or questions authorizing background checks. Next slide, please. All right. Yeah, sorry, I talked about this. Next slide, please. Um, in addition to the advertisements and the applications, the next big area in employment that this law applies it in is during interviews. So just like they're not allowed to ask you, on the application, just like there should be no language on the advertisement, employers are actually not even allowed to ask you about your background during the job interview. The only time that the background should be coming up is after the employer has made a conditional offer of employment. And that conditional offer of employment can happen after the employer has already looked at all the other qualifications, all the other things that you bring to that job, your training, your experience, the fact that you got a degree from BCC, the references that you have from your professors there, right? Any licenses that you may require that might be helpful for that job. The employer can look at all those other qualifications, and if they determine that the person is qualified for that job, they can make that conditional offer of employment. And we'll talk about what abilities the employer has after they make that conditional offer. Next slide, please. If during this process, right, before a conditional offer has been extended, the applicant asks whether a background check will be done, the employer should tell the applicant that it will only make that decision after a conditional offer. If the employer inadvertently discovers the person's background, they should ignore that information and continue the hiring process. I know it's a little unrealistic, and it may be difficult for an applicant to know that this is the case. But if the applicant were to somehow find out that the employer found out about your criminal history and decided not to give you that job, they could come to us and report that discrimination to us. Next slide, please. And so the conditional offer of employment is the very last step of the employment process. So again, the employer has already looked at your training, your experience, the degrees, your licenses. They've talked to you a little bit about your disposition and maybe any personal characteristics that make you a good fit for that job. And they've decided that they want to hire you. The employer can offer you that job, and only then and only then is that employer allowed to sort of begin asking questions about the person's background or conduct some type of formal background check. Next slide, please. And so this conditional offer can only be revoked based on the results of a criminal background check, right? And there's some more to that, but that's part of it, right? It could be the results of a medical exam when permitted by the Americans with Disabilities Act. For most jobs, it's going to be against the law for employers to ask you about any disabilities as well. That's something else for you to think about. But there are some cases where you may have to undergo a medical examination for a job, and where certain conditions may disqualify you or may be an issue from in participating in a certain job. And the last, sorry, and the last situation where an employer could revoke a conditional offer of employment is when the employer finds out something that would have led them not to give you that job anyway, right? I know it's sort of abstract, but let's say sort of hard for me to think of an example, but let's say you had a family member that worked in that business, and that business maybe doesn't allow former uh, family members of their employees to work there for maybe conflict of interest reasons, right? So the employer finds that out and they decide that they don't want to hire you, right? They wouldn't have hired you had they known that at the beginning. And so that could be used as a defense that the employer could use not to hire someone. But those are the only situations when a conditional offer um, could be revoked, right? For temporary hiring firms, a conditional offer is the offer to be placed in the pool of applicant from which the applicant may be sent to temporary positions. And these firms should not aid and abet an employer's discriminatory hiring preferences. So if an employer hires a temp firm to fill placements at that employer, just because the employer says don't send me anybody with a background doesn't mean the temp agency should cooperate and be helping them. The temp agency could be in violation of the law. The temp agencies also cannot fail to send people with conviction histories to assignments or give them less desirable placements, right? So sometimes it's not that they're aiding and abetting a particular employer, but it may just be that a person with a background goes to one of these temp agencies to find work, and they can't find anything because they have a background, because the agency refuses to send them anywhere, gives them the worst placements, gives them the worst, most undesirable, difficult jobs. That would also be a violation of our law as well. Next slide, please. And another thing to think about under our law is that regardless of whether a conditional offer has been extended, or I should say before or after a conditional offer, employers can never ask about and actually have to ignore non-convictions. So that means things like cases that are dismissed, cases where the person was acquitted, other situations like that. Cases adjourned in contemplation of dismissal, right? So ACDs, which are very common, youthful offender cases, which are supposed to be sealed or and only visible to sort of law enforcement and the courts, violations, sealed and unsealed, non-criminal offenses, and sealed cases, right? So employers can never ask about any of these and should actually ignore them. So a person should never be disqualified from a job based on a conviction they had that under youthful offender status, as an example, or just based on them having an ACD. Next slide, please. Employers should notify applicants that they should not disclose information about any pending cases for which they received an ACD that has not been revoked. And as I mentioned before, they should never inquire about or act on non-conviction information or ACDs that have not been revoked. Next slide, please. After a conditional offer of employment, the employer is allowed now to inquire about a person's criminal history. They can ask orally or in writing. They can ask about misdemeanor or felony convictions. They can ask about arrests or pending cases and driving infractions. But remember, right after a conditional offer, after the employer has already determined you to be a qualified applicant for this job and has actually expressed interest in hiring. Employers who want to hire, sorry, excuse me, if employers who want to hire someone with the record, they don't have to do anything else at this point. But if they want to withdraw that offer, they need to follow the fair chance analysis, which we're going to get into a little bit more in depth later. Next slide. Here's another video, but we can skip that. Yeah. And so the fair chance analysis basically says that the employer can only withdraw that conditional offer of employment, refuse to hire that person, or take an adverse action against them, including firing or disciplining them, related to their criminal charge or conviction, when they can explain the direct relationship between the criminal conduct and the job, or an unreasonable risk after looking at all the factors to people or property in that workplace. And so these are the exceptions to the rule that a conviction may not form the basis of an adverse employment action. Now, before we move on, right, I want to stop real quick and I want to ask you all what you think, right? When this slide says direct relationship between the conviction and the job, what do you think that means? And you can drop it in the chat. You can feel free to unmute yourself. There's no wrong answer. Just tell me what you think that means. Like when they say a direct relationship between the conviction, the criminal conduct, and the job, can you give me like an example of that, like what that might look like?
So I would say, for example, like if I'm applying to be a teacher and I'm being convicted of pedophilia.
Absolutely, right. So if you've been convicted of a sex crime against children
Yeah.
and you want to work in a school with children, right? You want to work at a daycare, right? These are situations where the employer may be able to articulate a direct relationship between the criminal conduct and the job, right? And they may be able to articulate, but number two, right, an unreasonable risk, right, between this person's history and the job, right? So absolutely, right. So something to be mindful of, right? Especially if we're dealing with a student or a person, an applicant that is recently coming home from incarceration or has a recent criminal history. You want to be mindful of which jobs you're applying for, right? We're going to talk about sort of how this plays out, and we're going to talk about the factors that the employers have to look at, because those things play a role as well. But just generally speaking, right, you want to be mindful of that. If you just came home from a conviction for bank robbery, maybe applying for a job at the bank might not be the best choice, right? Because the employer may be able to articulate this direct relationship and you may not be able to push back against it that effectively. But we are going to talk about that and how applicants
And
can
really
navigate
quickly, would you
that.
be able to give, because I'm struggling just a little bit understanding too, an unreasonable risk after looking at all of the factors to people or property. So like
Mhm.
I get like the real obvious ones, like the ones we just mentioned, but like what
Right.
would be something more, that we necessarily, the general population, wouldn't think that something's an unreasonable risk, but it could be.
Um, well, you know what it is? Like it is a bit subjective. It is broad. It does give employers some leeway, right? It does
And
give
that's what I
employers some
feel
leeway.
like when looking,
But
reading over too.
when we talk about the factors, I hope it'll clarify it more. But like, I wish I could give you a hard, solid answer, but unfortunately, the law is a little bit gray. There's sort of a lot of room to wiggle. And I am going to talk about things that applicants and employees can do to like improve their chances and help navigate this. But you're right, it is broad, right? What's an unreasonable risk to me may not be an unreasonable risk to the employer, right? The employer may say, "Oh, it's an unreasonable risk, because you had any conviction, right?" And I wouldn't think that's fair, right? But when we look at the factors sort of give a little bit of guidelines, right? And obviously previous cases, the case law gives some guidelines, but there's nothing hard or fixed, right? What I will say though, that's good for anybody who has a conviction history, as time goes on, there's sort of like this understanding that the risk that a person poses diminishes, right? So the risk of somebody poses, somebody who's just convicted, is going to be much different from somebody who's been home for 10 years and doesn't have a background, right? And there are some other factors that play into that as well, and which I promise you we're going to get into. It is interesting, but that's a great question, and I appreciate you for asking that because you touched on a good point. Next slide, please. So when we talk about the fair chance analysis and factors, right? When the employer is looking at the applicant's situation and trying to determine if there's a direct relationship or an unreasonable risk, the employer is required under the law to look at these following factors, right? Which I was mentioning. One of them is New York's public policy in favor of employing people with criminal histories. So that's basically New York State has sort of determined on the state level, we're a state that believes that people who have criminal histories have an opportunity to participate in our workforce. They should have that opportunity, and we are in favor of that. Number two would be the specific job duties and responsibilities, right? So, what is this person going to be doing? What is their background? How are we comparing those two things? Third would be whether the criminal record affects the ability to perform one or more of the job duties and responsibilities. So if the employer is claiming that there's an unreasonable risk or there's a direct relationship, but the job has and the job's duties and responsibilities are completely unrelated to that person's criminal history, then that may not be a good argument, right? That's the argument that we can push back against, that an attorney can push back against when they're raising a discrimination claim. They can say, hey, we get that you're saying that this person poses a risk because of their background, but a case that we had at the commission a long time ago, for example, we had an individual who he was denied a job working in a kitchen on like a five-star restaurant on Fifth Avenue in the city because he had conviction histories related to stealing cars. What does stealing cars have to do with cooking in the kitchen, right? Nothing, right? Those are two completely different things. Now, if the person was going to be the valet at the restaurant, that might be a slightly different conversation, right? Because the job is different, the responsibilities are different. So those things are going to play into this as well, and that's what number 3 sort of talks about. Number 4, I also mentioned before, how long ago the alleged or convicted conduct occurred, right? As time passes, risk goes down, right? As people sort of age and get older, they're less likely to commit crimes. As people sort of stay away from police contact and are and come home after incarceration, right? There's likely the likelihood of them being reincarcerated goes down as time progresses. Um, Next slide. Age is another factor, right? So 20, if the person's 25 or younger, that's considered a mitigating factor because of what we know about the brain's development, right? Of people, brains are not fully developed until people are 26. Uh, the seriousness of the alleged or convicted actions, right? Evidence of accomplishments such as rehabilitation or good conduct are things that the employer also has to consider. The employer is allowed to consider their interest in protecting people or property, and the employer must presume the applicant or employee is rehabilitated if they have a certificate of relief from disabilities or a certificate of good conduct, which are two things that I always recommend anybody who has any type of conviction history or justice involvement investigate, because those are things that can lend a lot of credibility to your case and make it easier if you come and file a complaint with us. Next slide. Um, when we talk about rehabilitation, good conduct, rehabilitation or good conduct, we could be talking about things like history of positive performance and conduct on the job or in the community, going back to school, vocational training, if treatment or training that's related to the circumstances that led a person to become incarcerated. So if a person was incarcerated because they were getting into fights and they had an anger issue, the fact that you completed anger management training is sort of part of your rehabilitation, right? So things like that. Any of those positive strides that you're making forward can be pointed to as rehabilitation. And employers must ask for information on all the factors that we mentioned as part of the job related analysis. Next slide, please. Um, yeah, and other examples could be proof of school attendance or counseling, evidence of community service, letters from people who can vouch for someone, teachers, parole and probation officers, and clergy. Those are also evidence of good conduct or rehabilitation. Next slide, please. If the employer reaches one or both of the conclusions, right, that meaning that they've come to the conclusion that there's a direct relationship between the criminal conduct and the job for this applicant, or that there's an unreasonable risk that this applicant poses to people or property in that business, um, the employer is allowed to revoke that job offer, right? The employer, however, must allow 5 business days for the applicant to respond to that notice. The notice has to be in writing, right? So and if the employer does conduct a background check on the applicant, the employer has to provide that background check, a copy of that background check to the applicant. So the applicant can see the same information that the employer is seeing, so they can see their background. They can see the same thing that the employer looked at when they came to their determination. We know that sometimes people's rap sheets or have errors on them. So one of the reasons for this is that for employees to be able to, prospective employees or applicants to be able to identify any issues that are on the rap sheet, and be able to challenge any false information that's on there. And during that 5-day period, the employer is not allowed to fill that job slot with anybody else. They must give the applicant the fair chance notice that explains how they came to their conclusions. They have to hold that job open for 5 days, and they have to give the applicant a copy of any background check that they performed on them. Next slide. Right. Um, Next slide, please. Employers that hired criminal background checks with the formal agency must turn over copies of those reports. If they search the internet or public records, they have to provide copies, including the date and time accessed. And if they use the oral information, they must summarize the information relied upon. And as I mentioned, right, the applicant or the employee should be able to see and challenge the same criminal history information that the employer used to come to their determination. Next slide, please. Employers are not allowed to use matrices or grids to decide that a certain criminal convictions automatically disqualify a person. And as I was saying before, the fair chance factors require a very nuanced, individualized determination. So there should be no sort of blanket rules or policies. It's sort of looking at each person's situation one by one, looking at the factors that each person, of each person surrounding each person's criminal history, looking at their proof of rehabilitation, their qualifications, and making those determinations on a one-to-one basis. And under our law, no type of conviction is an automatic disqualification from any job unless one of those exceptions applies, which we'll get into a little bit later. Next slide, please. Um, when we talk about the 5 business days, the time begins running when the applicant or the employee receives the information. And upon the request, the employer should be willing to engage in a constructive conversation, explaining how they came to their conclusions and identifying how the applicant might address them. So if the employer says that, the nature and the seriousness of the convictions were part of the reason that the applicant is being denied this opportunity, why the conditional offer is being withdrawn, the employer would need to also tell the applicant what it is that they could do to improve their chances of being hired in the future. And the employer can also offer a similar position that mitigates their concerns. So if they feel there's another position where the applicant would pose a smaller risk, the employer is allowed to do that under the law to say, hey, how about I offer you this position? I'll be a lot more comfortable with it. Next slide, please. Um, yeah, yeah. And if this fair chance analysis, right? A lot of the examples I'm using are for prospective applicants, but keep in mind, it could also apply to employers who are currently working somewhere. And so the same types of rules apply if the employer wants to take an adverse action against someone who's currently working there based on their conviction history. They would still have to provide a fair chance analysis and written notice. And the same 5-day rules apply before they take any adverse action. Next slide, please. Exceptions, right? So in terms of exceptions, right? Criminal background checks are required by federal, state, and local law for certain jobs. In those cases, the employer can inform the applicants that a background check is required before making a conditional job offer, but that language should not be in the ads or the postings for that job. And for those employers, they may conduct a criminal background check at any time during the hiring process. One thing to keep in mind is that they still have to provide the fair chance analysis to applicants and go through the fair chance process with 5 days to respond, even if they are allowed to ask people about their background check upon that person applying for the job. And an example of this might be like the daycare example. If a person wants to work in the daycare, background checks are required for that job. There are also transportation jobs. There are law enforcement jobs where these may be required. Next slide, please. There are laws that exclude particular convictions, right? So there are jobs that may prohibit an employer from hiring an applicant with a particular type of conviction. In those cases, the employer can tell applicants which convictions are disqualifying anytime after they apply. They can ask the applicants if they have any disqualifying convictions, and they can do a background check at any time after the application. And again, the employer still has to do a fair chance analysis if they decide not to hire that person. Next slide, please. police officers, peace officers, and civilian law enforcement, right? Um, they the the applicants are still not allowed to be discriminated against because of ACDs or arrests that did not result in convictions. But for most of those jobs, there will probably be background checks that they can do sort of before they offer you the job. Next slide, please. There are certain citywide government jobs designated by the Department of Citywide Administrative Services, financial jobs in the financial industry that are governed by the Securities and Exchange Commission and other regulatory organizations. Next slide, please. And as we wrap up, we're starting to get to our scenarios, right? So I wanted to know if I could get a volunteer to read this scenario, and we'll try to answer it together. Don't everybody volunteer at the same time.
I already spoke, so Brian or Crystal, one of y'all gonna have to.
I'm sorry, I'm chewing at the same time. Hi, Abraham. Sorry. Scenario 1. Sorry. Sharon has a series of misdemeanor convictions for trespassing, petty larceny, and drug possession from more than 10 years ago. From more than 10 years ago, when she was addicted to heroin. She has now been clean since then, obtained her GED, and worked as a cashier and a stocker in a clothing store for 2 years. Sharon applies for an assistant night manager job, in a competitor's store. When can the store ask about her criminal record, and can the store decline to hire her? You want me to answer it? Sure. Because it's been 10 years, I think that's a factor that should be considered. Also that she obtained her GED and has worked as a cashier and stocker in a separate clothing store. So they would have to say how this would be an unreasonable risk, or, well, of course, they'd have to offer her the position. And then if they deny her, if it's relevant to the current position, it's a misdemeanor, so it's not a felony.
So I guess my question is, do you think this would be relevant to her experience is relevant to this position? What do you think, like personally?
No, I say give everybody a job, but that's my own bias. Everybody should get a second chance.
So, thank you for volunteering. Thank you.
Yeah.
I appreciate it. So one thing I also want to know: all of these scenarios are based on actual cases that we've had, and so in this case, we would rule our approach is you got it 100% right. The employer can only ask after they offer her the job, and no, the store cannot decline to hire her because she's all her convictions are old, right? They're more than 10 years ago. That's a lifetime ago, right?
Yep.
She's been in recovery since then. She's obtained her GED. She's been working at a store for 2 years already, right? So this store should not decline to hire her based on her conviction history, right? We would consider that a violation of our law for this particular scenario.
Abraham, I have a question though. Can I ask
Sure.
it? Okay. What happens if they deny her and provide like a different excuse?
Then that may not be discrimination for based on conviction history. However, if so that's one of the reasons why the law is constructed as it is, right? Because if the employer is allowed to ask the person about their background up front, it believes what I think you're alluding to, like some type of proxy discrimination,
Yeah,
right? Where
that's
they
what I
say,
was
hey,
wondering. Yeah.
because they could say and legally say, hey, we don't want to hire you because we don't think you're qualified for this job. We
Yeah.
don't think your 2 years of experience
Is
is
enough.
good enough for you to be a night manager.
Mhm.
And that would be fine. If they said that, that's completely up to them. If that's what happens, and that's all we have, they're allowed to do that. There doesn't appear to be anything illegal there, right?
Yeah.
Now, if they offer her that job and then they say, oh wait, but you have this background stuff, we can't hire you. It becomes much more obvious that the background is like the reason, right? Like, or even if they don't say that, right? They ask about the background, they offer the job, they find out about the background, and then they withdraw the job offer, right? Even if they don't say that it's because of the background.
Yeah.
It sort of creates an environment where it's easier to prove that it was because everything was fine. And so But it is a good question and it is imperfect, and some employers still do that. So it is something to be mindful of. The employer might ask the person about their background and then say that they don't want to hire them because they believe they're unqualified, right? But then that will call into question why they offered her the job to begin with. You know
Or
what I
it
mean?
could be that they
Yeah.
might say, oh, we found someone actually a little bit
Right,
more
right.
qualified.
And so, and those things would still be discrimination, but it just
Oh, okay.
it shows how discrimination is very hard to prove sometimes, because
Yeah.
discrimination is not obviously the worst. The most obvious types is like the employer saying, hey, I don't want to hire you because of your background. But it could also be misrepresenting the availability of the job.
Yeah.
It could be sort of trying to, hide behind other reasons why they don't want to hire that person.
Mhm.
But that's why, like, when the Fair Chance Act was designed, that the employer has to look at all the other qualifications first.
Mm,
So that way you can't pop up at the end and say, oh, it's because you don't have enough education. Well, then why'd you offer me the job, right?
yeah. What
If
if,
it's because of what, if it's because I didn't have enough education, why'd you offer me the job and then
no, it's
withdraw it
true.
when you did the background check? And so it makes it easier, but it is imperfect for sure.
So Sharon would have to contact you guys, like if
Yes, yes.
she
If
felt
she
like
if
there was
she felt
discrimination.
like, let's say, they misrepresented the availability of her job, maybe like
Yeah.
maybe this employer is smart and they don't tell her that it's because of her background,
Yeah.
but they offer her the job, do the background check, and she doesn't hear from them for a few weeks, and she calls
Yeah.
them, and then the employer says, "Oh no, we found somebody else."
Yeah.
Sharon might want to call us, and
Got it.
then, okay, well, let's look into, did they really find somebody else? Who did they find?
Okay.
Right?
And
Yeah,
would
but that
Sharon need like a condition offer written, or could it be verbal?
it can be verbal. It does not have to
Oh,
be written.
oh,
Yeah.
good to know.
hmm Um, let me see. Brian, are you able to read, or I might have to pick on Tiffany again?
I can read. I can read.
Thank you. Thank you. Yeah.
No problem. David was arrested for and convicted for burglary in the second degree, a violent felony offense, when he was 19 years old. It it is his only conviction. He was incarcerated at Rikers Island for 6 months and is currently on probation. After release, he immediately enrolled in a 6-month culinary arts program, which he recently graduated with a food handler certificate. He's now 21 years old and applies to be a cook in a hospital cafeteria. Should I read the questions as well, or?
Yes, yes. And then let me know what you think, your personal thoughts on it.
All right. When can the hospital ask about his criminal record? Can the hospital decline to hire him? So my assumption is that the hospital can only ask him about his criminal record only after they gave him an offer, and the hospital can decline him only if they see there's some type of I forgot the exact word that was used earlier, but if the criminal
That the
offense
direct relationship,
matches, yeah, if there's like a direct relationship with the criminal offense to the hospital, then they
right?
can decline him.
Okay. Do you think there's a direct relationship here in this case?
No, not in this case, no.
All right, cool, cool. All right, so I'm gonna give you the answer, and I see Dr. Crystal's on there. She's on to something, right? So this one is kind of a trick question, but I'm glad that you said that, Brian, because yeah, I want to deliver that point home. Most employers are not allowed to ask about that criminal record up front. Hospitals have sort of an exemption. They are permitted to ask about criminal records up front. They're not required to. I think for at least not for all the jobs in the hospital, at least, but they are permitted to conduct background checks up front. So if it is a hospital, they actually can ask up front, right? But for most other jobs, they would not be allowed to ask. And in terms of the hospital declining to hire him, we would also say no. There's a number of different reasons why. Like when we look at the factors, his conviction was when he was 19, right? So his age is a mitigating factor. He's doing something that's completely unrelated to what his conviction history is for, right? You see he has some proof of rehabilitation, right? He went to school, to the culinary arts program. It looks like he's taking the steps to sort of move forward, right? So we would say no, that the hospital cannot decline to hire him. If they were to decline to hire him, they would still have to conduct that fair chance analysis and sort of try to justify what it is, and that will open them up to sort of a challenge from us, right? Like if Stephen, excuse me, Davis comes to us and says that the hospital didn't hire him and he felt like it was unfair, it would still, he could try to challenge that. He could try to say, hey, that was 2 years ago, culinary program, I'm on probation, I haven't violated, I'm almost done. Been doing X, Y, and Z other things, right? I go to BCC at night, all those types of things. Next slide, please.
Abraham, can I ask you a question? Not sure if
Sure.
you would have this offhand, but
Sure.
the number of cases that like go to you all, like what's the clearance? Like how often does the employee win versus
I
the employee?
don't have that on offhand. What I would tell you is I can share with you information about our annual report. So our
Mhm.
last year's annual report, I think, would have those numbers.
Okay,
But I will say I know that a lot of the cases go to settlement, which I
okay.
know probably sounds bad, but from what I understand in like the legal world and for this type of law,
Mhm.
that actually is like a good outcome because
Okay.
although sometimes the entity does not admit guilt as part of
Mhm.
these settlements, it's sort of like there are concessions that are made to sort of try to fix whatever it was that happened, whether it's them doing their internal training,
Mhm.
disciplining workers who have been found to be participating in discrimination, and sometimes even like payouts, right? Financial
Oh,
compensation, which
wow.
we'll talk
Okay.
about later,
Mhm.
compensatory damages that go to the person that experienced discrimination, civil penalties that they have to pay to the city. So
Oh,
even though
wow.
a settlement may not be considered like a trial win,
Mhm.
I know that a lot of the cases sort of are perceived as wins. So I know it's not that helpful, but you should definitely visit our website, or I can share it with you later. I'll
Okay.
make sure I drop my information in the chat too, and you can check out our annual report, and it has numbers on all of our cases, how many went to settlement. I don't know if it says like if there's like a win column though. I'm not
No,
100%
no, no.
sure
I'm
about
just
that.
wondering because I know a lot of students who'd be like, "Well, I was just applying for, this job just to make a little bit of money. It's not my career job, but like, would they want to
Mhm.
go through all of this?"
Right, right.
So just wanted to have some of that data.
Yeah, I mean, that is something to be mindful of. And I think that is one of the reasons why a lot of people don't sort of report because it can be a lengthy process. But the way we try to look at it or encourage people is like, look, let's say you file, even if you don't get the job back, even if you don't want the job that bad, even if you don't get a whole bunch of money paid out to you because of this discrimination, a lot of it is just making sure that everybody gets a fair shake, right? And if we don't report these types of discrimination, the entity can continue discriminating without consequence. And even if it doesn't affect you because you go somewhere else, it's gonna affect the next person that's coming behind you, right? And I know that's probably not gonna convince everyone, but that's how I try to convince people. And it's like,
No,
that's
that makes sense.
it's one small thing we could do to try to foster a better city for everyone, you know? Um, yes, so scenario 3, right? I've run out of people to pick on, so I can read this one.
I'll read it, Abraham. I got you.
Okay, yeah.
Scenario 3. Tony was arrested for and convicted of grand larceny in the second degree, a Class C felony, when he was 24 years old. Released from prison after 5 years, he became homeless and had 4 separate misdemeanors for trespass and turnstile jumping up until a year ago, when he was admitted to a shelter with a transitional work program. Now he's 31 years old, just earned his CDL, and applies to be a driver for a long distance moving company. When can the company ask about his criminal record? So after a conditional offer, I guess grand larceny, the question would be if he stole a car or something. Can the moving company decline to hire him? I would say that they need to prove those 2 points because he was under 25 years of age. And although he's had some misdemeanors in the last year, he's done so much to prepare for a job. So I don't know. That's tricky. I think they can technically, maybe, but if I was the company, I'd hire him.
Right. So yeah, this is a tough one, right? This one is a little bit more gray. You were right though. The company can only ask after they offer him the job, right? I'm glad that everybody has that. That's good, right? In terms of the company declining to hire him, it is much more of a question mark, right? His age is definitely a mitigating factor. You know, how he has had some recent um convictions, even though they seem to be minor, right? You know, his work history has not been sort of very consistent. He's coming off of a period where uh he hasn't been working because he's been homeless, right? He has
That's
gone
really an
and
issue
made.
for the correctional system. Like they should have prepared him for reentry. So,
Oh,
um,
listen, you're preaching
yeah,
to the choir, but I'm just telling
yeah,
you,
yeah, yeah.
it
No, no, I'm
gives
just
it
saying,
gives them
like he
leeway.
wouldn't jump a
Yeah,
turnstile if he had money, if we gave him a job.
right.
So it's a
If we
cycle.
funded our public transit system properly and it could
Exactly,
be free like
exactly.
other places, yeah, right, yeah. But yeah, nah, I hear you. But unfortunately, it does sort of give rope to the employer to sort of look at those things. However, he did make the effort of earning his CDL, right, which is a good step forward. Um, his felony is not the most serious level, but it's serious, class C. Um, I think one of the issues with this case, right, that makes it a little bit different from the other ones, right? He does also the time also does play in his favor a little bit because it has been some years since this conviction, not as many as like with Sharon earlier. And he's also not as young as Davis was in the previous scenario, so it makes it a little bit tougher for him. But there has been some time between this conviction and the present. However, the type of conviction, right? It's a grand larceny conviction, right? And he's doing a long distance moving, right? So I think, right, this is a gray area, right? I would also like for the employer to give him a shot, but I could also see the employer sort of stating, grand larceny, right? You're stealing belongings, right? We're talking about belongings that cost more than a certain amount of money. You're going to be transporting valuables or at least property of other people that could cost more than a certain amount of money. So I think it raises that question for the employer, right? Like that may be an area where the employer can kind of make that argument. And for somebody like this, this is another situation, right? Like where I would want this person to really focus on getting all the proof of rehabilitation they possibly can, right? Because their felony is a class C felony. If this was in New York, they are eligible to apply for the certificate of good conduct, right? So I would, yeah, reach out, try to get the certificate of good conduct. That's something you should be thinking about, right? And if even if you don't get this job, what are some other things that you can do to sort of improve your standing, right? If you're doing anything in the community, if any of the people at these programs can write letters for you and vouch for you, these are things that you want to have in your favor. And so like that's what I would tell Tony. But this situation is definitely a little bit tougher and not as clean cut as sort of the other two that we looked at. But also, again, just like with the other two, if the employer were to decline that job to him, to withdraw that job offer, they still do have to conduct a fair chance analysis. They have to look at all the factors, and so that's why sort of having proof of rehabilitation, having those positive things, could really play in his favor if he has them. Next slide, please. Carol and Joseph, I think we have 5 scenarios, so just bear with me. We're almost done. Carol and Joseph are assistant managers at a department store. They went together to a demonstration and were arrested for unlawful assembly and resisting arrest, which are misdemeanors, and disorderly conduct, a violation. Their cases are still open in court, and the employer is considering to fire them. Can the employer fire them because they were arrested? Can the employer place them on leave? And does the employer have to follow the fair chance analysis? What do you all think?
No, you can't fire for arrest because it's not a conviction.
Mm-hmm.
No,
Mm-hmm.
can't put them on leave. And yes, they would have to follow the fair chance analysis if the person was convicted of the crime.
Right, right. Yeah. Okay. Okay.
I like these
Um.
scenarios.
Yeah. In terms of, let me think. Can he put them on leave? That's a tough one for me. I think I'm struggling to remember, and I'm gonna have to reference my notes because I haven't done this scenario in a while. I think the employer may be permitted to put them on leave, but I need to understand there is some sort of caveat to that. It's not just sort of um them just placing them on leave for no reason. There's something more to it. Um, okay, so if the employer can place the all right, this is what it is. The employer can place the employee on leave when they're conducting a fair chance analysis, but the leave must be a reasonable amount of time, right? So also if the employer does want to, you're right, the employer cannot fire them based just only on an arrest, right? Um, However, one thing that I want to make clear to everyone, right? Any sort of political activity is not necessarily protected under the law when we talk about discrimination. So, the nature of the arrest, the nature of the employer's business might play a role in sort of the actions that the employer takes. But the employer, irrespective of like what they decide to do, they would have to conduct a fair chance analysis before they take any adverse action. If they're gonna do a fair chance analysis based on this particular arrest, right? Meaning that they want to take adverse action, they can't place them on a leave. It would normally be around 5 days. It has to be a reasonable amount of time. It can't be an extraordinary long amount of time. But they could do that in this situation. But another thing, right? Your politics are not really protected, unfortunately, in the workplace. So it's just something to be mindful of. Next slide, please. So here's some quick tips for employers, right? Make sure your applications do not ask about arrests, convictions, or authorized background checks. Train employees to make no statements or inquiries, either of the applicant or another source, about criminal history before a conditional offer. Never ask information about non convictions, ACDs, youthful offender cases, violations, non criminal offenses, or sealed cases unless an exception applies. And always follow the fair chance analysis unless an exception applies. Next slide, please. And tips for employees: know your criminal record before you look for a job, right? So we have a list on our website at this page where we can have organizations that help people look up their background histories to make sure they know exactly what's on their rap sheet, make sure there's no issues there or anything missing. Unless an exception applies, do not share your criminal history or give permission for a background check until you receive a conditional offer of employment. So generally, we'll encourage people not to share that information with employers, which flies in the face of the advice that we used to give a long time ago before the Fair Chance Act. The advice that a lot of workforce development organizations would give would be to tell the applicants who have conviction histories to disclose their conviction records up front. So because of the Fair Chance Act, that's sort of the opposite now, right? You don't need to tell your conviction history until you're being offered the job in the vast majority of cases. Unless an exception applies, you do not have to disclose the non-conviction and ACD, YO cases, violations, non-criminal offenses, or sealed cases. Of course, we don't expect everybody to know when an exception applies. So we encourage people to, just try to advocate against not disclosing. If an employer pressures you into disclosing and you disclose and you end up not getting the job, you can still file a complaint with us. Next slide. If the employer decides to withdraw a conditional offer, fire, or discipline you, you are entitled to a fair chance analysis in writing. You have at least 5 business days to respond. You should always respond to the fair chance analysis. The protections apply even if an arrest or conviction happened in another state. And adding on to this, I would encourage all applicants to try to assemble as much information as they can that shows proof of rehabilitation or like thinking about the certificates of relief or good conduct. You want to apply for those things as soon as you can. You want to begin assembling those things as soon as you come home. So that way you sort of build up this record of all the positive things you've been doing and if a situation does arise, you're prepared. You don't have to scramble and find everything. You have a copy of your rap sheet, you have the letters from your employer, you have your certificate of relief or good conduct in a folder prepared, right? You have your references, you have the people at your school that can vouch for you, the people at the counseling program, the substance abuse program, whoever it is that's been working with you, that's seen that person's progression. Next slide, please.
Abraham, I have a question. Is
Sure.
there a template that someone can fill out, like to respond to the after the 5 days?
I'm not sure if there is. I know we have a template on the other side. We have a template for employers so they know exactly what the fair chance process is and like how to comply with the Fair Chance Act and do the fair chance analysis. I don't think we have something for applicants, which is actually a good idea, and I'm going to write down, and I can elevate that to our leadership
Thank you.
because I do think that's actually. I'm surprised nobody else thought of that.
Because I'm thinking about like a student who recently asked, who has a criminal history from 7 years ago, a felony, and to like give them a template with like a checklist on what they can apply to or like submit might be super helpful.
Right. What they could apply to or submit.
Like meaning like the template, like if I have only 5 days, I'm not sure what I need to get together, and that might be really helpful, like a checklist or a template that I fill out so I can respond to the employer.
Got you. Okay. Um, can you sorry, one slide back. Oh, are you gonna jump in, Ayad? Or you gonna wrap up? Or
Hey, yeah, so one moment, please. Let me, I don't have two screens, so I'm like
I got
in
you.
between.
Yeah.
But did you finish here?
Yeah, yeah. I pretty much
Oh,
finished my
yeah.
other parts. Yeah. I'm gonna leave my information in the chat.
Mhm.
Um, and
Yeah, please do, because and I encourage everyone to reach out to Ape. I myself, reach out to Ape because he's the expert on this topic, the Fair Chance Act, and you know, he has been working on that for a very long time. And I appreciate you, Abe, for being here with us and giving back to the Bronx, and especially the Bronx Community College. And, before I wrap up, I just want to explain the process, right, and how it goes. So the intake and the complaint process in the commission, and what you should expect when you visit one of our offices, in any borough. So we do the intake right after you submit your complaint. The law enforcement bureau will do the initial intake, and then the complaint is filed, and then there's an investigation. Those are our lawyers and investigators. um, you know, they come up with different, sorry, one moment, please, because Zoom, but what I was trying to say is, there's different, if you want to go, how to go about it, meditation, and or if you want to draw your complaint, dismissal, or the fourth step is determination, and how is that being determined, with an outcome under a protected class, and trial, and much more. But until you go through the Office of Administration, the oath, the Office of Administrative Trials and Hearings, and then the Commission's Office of the chairperson. As mentioned in the beginning, they are the ones who will make the decision afterwards. So, with that being said, or Ayad, from the Bronx CSC, or the Bronx,
let me.
yeah,
Sorry, I just want to leave with one more story that just came to mind very quickly. Right.
yeah,
So
please
we had
do.
a case that's actually relevant because in the Bronx, there was an individual he worked for. So I may be getting some of the details wrong, but I'm pretty sure it's on our website, so you could definitely fact check me. I mostly just remember the money, which is the most important, and some of the other details of the case. So, the person was working at Montefiore Hospital, I believe it is. And I think Montefiore was either purchased by the Albert Einstein Medical Center or vice versa. But either way, the entity that ended up purchasing that medical center decided that they wanted to do background checks on all the workers that were there. So this individual had been working there for some time. I think he had been working there for like several years. And so they did background checks on everybody. They found out about his criminal history, and they decided to terminate him, even though he had been working there for years. He came to the commission, he filed a complaint, and I can't remember, I believe the case was settled, but I think the resolution, part of the resolution in that case, they were not able to get him his job back, but they were able to get him a total of $110,000 in compensatory damages. 40,000 of that was back pay, and 70,000 was for his mental and emotional distress related to the discrimination that he experienced. So you could definitely check that out. Look for that on our website. I think it's from 2020 or 2019, that case, but super relevant, especially since we're talking about the Bronx.
Abraham, so he didn't get his job back?
No, in some cases we are able to get people back into the jobs. I don't know the specifics of that case, why they were not able to. Yeah, and I'm not
Or
sure.
maybe he
Or maybe he didn't
chose,
want it. Yeah, he didn't want
right.
it maybe anymore by the time, because it is a lengthy process. Like, I'm sure it wasn't overnight. Like, he probably filed, and months go by and stuff like that. So that could be a possibility. Like Ayad said, I'm not sure, but I do know that in some other cases we have been able to get people their jobs back. So, and every
Right.
case is different. This is also like, that's the other disclaimer. I'm not, don't leave here and say Abe said we're gonna get $100,000 if you file. Don't say that. That was just one case, right? Every case is different. Every case is going to be determined on the merits of that particular case, on the egregiousness of the discrimination, and the facts that our lawyers have, right? Obviously the resources of the entity probably play a role into it as well, and the practices that they're engaging in, but it's going to be very specifically based on that situation. There's no blanket rule, but it's just an example of what could happen when people file complaints. Thank you again all for your time, and feel free to reach out to me or Ayad if we could be of any assistance. Definitely want to keep
Yeah.
our relationship strong.
Yeah, please. And I will put my information on the chat as well. So, for folks, please don't hesitate to reach out. Let
So
me
Crystal
just.
actually just headed out. Let me just close out this recording. Thank you all who were here and those that are watching. If you have any questions, feel free to email me at civicengagement@bcc.cuny.edu. Thanks again.